Hello and welcome to Street IAS. My name is Shashank Roy, and we are here with a new topic related to not related to geopolitics but related to social justice and women empowerment. We all know that Sabarimala verdict was given in 2018. There was a review petition in the Supreme Court, and Supreme Court Constitutional Bench is reviewing the decision taken in 2018, and that was related to entry of women in Sabarimala temple, which is dedicated to Lord Ayappa, who is known as a celibate god. Now, Justice B.V. Nagarathna, one of the judges, the only women judge in the Supreme Court as of now, among those nine judges who are leading this constitution bench, she is the only woman. She has observed that you cannot treat women as untouchable only for 3 days, and after that, you treat them normally. So this is related to Article 17 and untouchability, and we will talk about multiple dimensions of women empowerment and custom traditions and the conflict arising out of it. So women not untouchable. The Indian Express article says there can't be 3 day untouchability. Article 17 can't apply for 3 days, and the Hindu has published about the same. So before we proceed and go to the slides, we will do some homework here. First of all, I would like to know about what constitutes women empowerment. What constitutes women empowerment? So if we go by the preamble, we we have spoken about justice, social, social, economic, and political. And in preamble, what we have said in preamble, sorry, justice. So, in order to ensure women empowerment, we have paid attention to justice, social, economic, and political. Right? So, these are the three dimensions under which we try to. It's not only related to women empowerment, it is related to empowerment of every Indian citizen. But since this matter is related to women and their biological process, we are talking about the women empowerment only. But so here, social justice, economic justice, and political justice. Article 17 talks about untouchability of women. Article 17 talks about untouchability, abolition of untouchability, abolishing untouchability by Article 17. What does that mean? That we have abolished every forms of untouchability in forms and practices. But here, in this Sabarimala related case, there is 3 day ban. Women are not allowed to enter into Sabarimala temple during their menstruation period. And this menstruation related concept is related to purity and pollution. If we talk about menstruation as a purity and pollution related concept, there is no legal validity of this concept of purity and pollution. There is no legal legal backing, and at the same time there is no any scriptural evidence which says that there exists a purity and pollution concept related to women and their menstrual cycle. So this is what Justice B.V. Nagarathna says, that why do you treat women as untouchables? Why do you treat women as untouchable during those 3 days, and after 3 days everything becomes normal and Article 17 becomes applicable? So during 3 days, when a woman is going through her menstruation cycle, she becomes untouchable and Article 17 becomes violative, and after that everything becomes normal. So why this selective outrage? Why this selective discrimination? For normal days, you maintain Article 17 abolishing untouchability, but why treat women as a second class citizens for no fault of theirs? It's just a biological process. Recently, few years back, there was a movie related to Padman, which was related to sanitary napkins. But nothing changed. Still, sanitation, menstruation related talk is a taboo in a country like India, which needs to be debated and discussed. So, let's move on to the article now. In Before we proceed, I'll cover one more dimension. Recently, UPSC asked a question related to care economy. UPSC asked a question related to care economy. When we say care economy, we also talk about unpaid care work, unpaid care work. At the same time, few days back, Kerala approved period leaves, period paid period leaves, paid period leaves means during those 1 or 2 days you will get a paid leave from your organization, which was hailed as a landmark decision, landmark legislation. So there is already communication going on related to care economy, unpaid care work done by women for which they do not get any credit, or paid menstruation leave. So communication is going on related to this, but we have miles to go. So the UPSC syllabus says GS paper 2 polity and governance, fundamental rights, article 17, 14, 17, 21, 25, role of judiciary in social reforms, constitutional morality versus religious practices, constitutional morality versus religious practice, and this matter is also related to ethics. So constitutional morality, what constitute constitutional morality, and what are religious practices, and how to maintain a balance. So it may be a case, it may be a classic case, classic point for case studies. Case studies. Okay, issues related to women, GS paper 2 society, women and social practices, intersection of religion and gender justice. In ethics or essay, there can be question related to tradition versus modernity, dignity versus faith. Whom should be given importance, the dignity or the faith, the custom, constitutional morality, or the religious practices? So they can be a part of ethics case study as well. Now look at, these are the images taken from related to Sabarimala temple, and hordes of and here the protest is going on. Supreme Court and the Sabarimala verdict. Now, issues. The Supreme Court is re-examining the 2018 Sabarimala verdict. Justice B.V. Nagarathna, the only female Supreme Court judge in this panel, Justice B.V. Nagarathna made critical observation, and she says that can menstruating women be treated as untouchables? Can Article 17 be applied selectively only for 3 days a month, and after that everything becomes normal? Now, the core constitutional question is exclusion of women a religious practice or a violation of fundamental right, and how to maintain a balance between religious practices and constitutional morality? Team, is that clear? How to maintain balance between constitutional morality and religious practices, faith versus dignity, and the constitution. So again, is exclusion of women a religious practice or a violation of fundamental right? In the name of religious practices, can you violate the fundamental right, especially when we have a secular constitution? So, flow of the argument. Justice Nagarathna says women cannot be treated as untouchable even temporarily, even not for, forget about 3 days, even for 1 hour. Article 17 abolishes untouchability in absolute and not conditional. You cannot be selective in application of Article 17. Article 17 is absolute in its application. It's 24 by 7 by 365 regardless of gender. You may be male, female, or transgender, but untouchability is not at all propagated, not allowed to be propagated in any form. Right? So, Article 17 abolishes untouchability in absolute terms and not conditional. So, treating menstruation based exclusion is untouchability expands Article 17 beyond caste, major constitutional shift. Regardless of caste, creed, color, right? Article 17 is applicable uniformly, and it is applicable not selectively, it is applicable in absolute term. This is what Justice Nagarathna says. Now, Solicitor General Tushar Mehta made some observation as well. 2000, he says that 2018 was a wrongly decided judgment. Sabarimala is sui generis, means it's a unique case in its own. Restriction is not about untouchability but about religious denomination practice. So should the religion take precedent before the constitution? And what about the constitutional morality? What about the dignity of the individual? Should faith trample the status of dignity? Should the untouchability be applied, selectively? Should we look at the caste binary? Means the untouchability will not be applied to the upper caste. Anyways, untouchability is not at all related to upper caste. It is related to the downtrodden people of the society. Now, not 3-4 days exclusion, but an age-based. Solicitor General says that it's not a 3 days exclusion, but an age-based. Other Ayappa temples allow women. This temple is unique. Lord Ayappa's temple, there are multiple temples in India, but this Sabarimala temple is the only temple of Lord Ayappa when menstruating women of menstruating age are not allowed to enter into the temple, or they are not allowed to enter during those menstruating period. So warning, if accepted, opens door for religion specific exemptions for from fundamental right. So if we allow this to happen, Justice Nagarathna says that if we allow this to happen, this will open the floodgate. Multiple religious denomination, multiple religious institution will come forward and they will try to enforce this religious practice against the fundamental right related creed of the constitution. Now, court's clarification on religion. Court says that it is propagation is not forced conversion. Propagation, right? You have every right to propagate your religion, but propagating your religion is altogether different from forced conversion. You get the fundamental right, you get the security, you get the fundamental rights related protection only related to propagation of religion, not the forced conversion. By giving false claims, by persuading people or alluring people through different kinds of means, that is not at all allowed. So propagation does not mean forced conversion. Constitution protects faith and not the coercion. Coercion has a negative connotation, means you are luring them through the money power, right, or material benefits, or you are misguiding. And all these forms of propagation, they do not come under propagation, they are coercion. So this strengthens Article 25 interpretation. The key constitutional provision related to this: fundamental rights clash. Article 14 talks about equality before law. Article 15 says no discrimination. Article 17, abolition of untouchability, and Article 25, freedom of religion. So these are four articles which are at the center of this entire Sabarimala verdict, which is going to take place soon. Next, the real battle. The real battle is individual right versus religious freedom. Individual rights are equality, religious right, denominational autonomy, right? Dignity of the individual versus essential religious practices, bodily autonomy versus faith related tradition. So there will always be clashes. There will be always be clashes between individual equality, individual dignity and bodily autonomy, and religious practices under denominational autonomy, essential religious practices, and faith traditions. So there are multiple issues, such as issues related to Daudi Vohra's community, essential practices, right? So this is one, the real battle. The critical analytical dimension of this article is Article 17 expands debate. Traditionally, there is a caste based untouchability still practiced in hinterlands of India. Hinterlands of India, which still do not subscribe to constitutional principles. Constitutional principles, right? So traditionally, there exists a caste-based untouchability. Now, can it include gender-based exclusion? Can it exclude gender-based exclusion? Can't it include gender-based exclusion? Now, over-expansion may dilute original intent or strength of social justice. So, this is what this article says, that Article 17 traditionally caste-based untouchability is there, but now can it include gender-based exclusion as well? Now, essential religious practices doctrine. What is this essential religious practices doctrine? Which means that every religion has their own philosophy. Every religion has this own creed, and they are practicing, they are continuing these practices for the thousands of years, and they justify it. That since we are practicing is for the past 1000 years or 2000 years across the world, it should not be changed. But it should be changed if we go by the constitutional principles. So here courts decide what is essential to the religion. Now, in the name of essentiality, there must not be a karmkand. In the name of essentiality is different thing from karmkand. So here it says that court decides whether it is essential to religion or not. The criticism is judiciary is interfering in religion and subjective to, and it is open for subjective interpretation. Now, every practice which is continued for the past 1000 years, right? It may be related to female genital mutilation, which is practiced in various communities, not Daudi Vohra community, or it may be related to other religious practices. The question is, are they really essential? or you are justifying it because they are being continued or practiced for the past 1000 or 1500 years? That's the bigger questions. So now when the Supreme Court is going to check whether this is a part of essential religious practices or not, then it may be taken as a judicial interference in religious matters, right? So it may be open for subjective interpretation. Few people will be happy and few will not. Now, what is constitutional morality versus social morality? Constitution or prioritizes individual dignity. Society may prioritize tradition, and that's where the conflict will come, and this conflict will lead to ethics case study, where your approach will be seen towards handling of conflicting situations, right? So constitution prioritizes individual dignity, whereas society may prioritize tradition. They may call a traditional practice as essential practice, but Supreme Court will decide whether a practice is essential or not. Okay, so now UPSC inside court often upholds constitutional morality because we have made constitutional practices or constitutional morality as a creed. So constitution often upholds constitutional morality instead of going by the tradition or giving priority to the tradition. Now, gender justice versus faith. Menstruation is a stigma, which is a social issue, and this social issue must be debated thoroughly. And this is one of the biggest reason this is still a taboo in our society, and there is a cost to the economy. If we remove this taboo, we can ensure a dignified existence of women. We can ensure their participation in workforce. We can make them comfortable, right? And it will reap great dividends. It will contribute at least 2% of the GDP. But because of this taboo, right, there are women who are leaving their schools, who are unable to go to schools, right? Who are not comfortable at workplaces, or who are forced to take leave during these difficult days. So this needs to be discussed. Menstruation stigma is a social issue. Religious argument is celibate deity Lord Ayappa. Now, menstruation is just a biological process related to fertility, and it should not be stigma. In fact, it should be a sign of fertility has already always been worshipped in India or in any other civilization. So how come that biological process can be stigmatized? But what religion says, what the temple authority says, that celibate deity Lord Ayappa is a celibate deity, and there must not be any women who is menstruating, and that's why this ban is there. Now, warning: sensitive balance. There must be a sensitivity must be balanced between judiciary. Judiciary must avoid any majoritarian backlash, but should judiciary be afraid of majoritarian backlash? Should judiciary be afraid of taking any decision that is related to non-religious essential practices? There may be a practice, but that may not be essential for a religion or a faith. So, focus areas for mains answer. UPSC might ask question related to whether Article 17 applies beyond caste, limits of religious freedom, role of judiciary in social reforms, and gender justice versus tradition. Again, this is the framework for mains answer writing. If you wish, I can send you the PDF. This is the mind map and final takeaway. This case is not just about temple entry, it's about redefining equality in India, testing limits of religious freedom, and expanding scope of fundamental rights. So this is it in this article. We will get back to you with some more details. Till then, thank you so much. Wish you a wonderful day ahead. Jai Hind, Jai Bharat.